Hi, everybody. This is Dave Stouse, a partner at Husch Blackwell. I'd like to welcome you to our webinar program today and thank you for joining us. The topic of today's webinar, as you can see up on the slide deck, is analyzing the Colorado Privacy Act rules. A couple housekeeping items as we start to jump into this is first, you can access our LinkedIn profiles using the QR codes there. Or if you have questions during today's webinar, you can feel free to shoot us an email. We invite you to friend or follow us on LinkedIn. It's a good way, I think, if you're interested in this topic to track it. Obviously, we talk about not just the Colorado Privacy Act, but a lot of different things, all things privacy law, and obviously a lot going on in California right now as well. Some other housekeeping items. We have lots to cover today, as you might suspect. There is 38 pages, single-spaced rules to get through and try to give you some context for it as well. So if you have questions, feel free to ask the questions. We'll do our best to try to address them throughout the course of the webinar, but let's just admit it, it's going to be tough for us to do all of that. But feel free to ask questions. We get them afterwards, and if we haven't answered them, we'll do our best to reach out to you and see if we can get you an answer. Okay. I always get emails afterwards asking me for the deck and asking me about CLEs. So the deck is available on the platform. I believe you can just pull it up as a PDF. And then CLEs, I'm told that you have to stay on for like 45 minutes, and then the ability to get CLEs pops up or something. And also you get an email afterwards that provides you the CLE information. Okay, so if you have attended one of our webinars before, I suspect some of you have, we like to start off with a roadmap of what we're going to talk about. The hope is you guys can kind of see where we're going in this whole thing. Maybe it heads off some of your questions, and you guys get an idea of what we're going to address and when. There's a lot of topics. Obviously, there's a lot of topics, 13 of them right here. And I'll just say, despite the fact that it's a singular topic, i.e. the draft rules here today, there's a lot of nuance here. We're going to do our best to get you guys into as much of that nuance as we can, but we can't get into every twist and turn here. Okay, so let's start then with 5 takeaways before I turn it over to TK to give you a current status. So this is just high level, right? If you leave with nothing else, at least you leave with the 5 takeaways here. The number one there is, it really kind of immediately comes to mind when you see the draft rules, which is, even just looking at them now, they're 38 pages long, right? And when you compare that versus just the CPA itself, the Colorado Privacy Act itself, which is 31 pages, you get the point, which is there's a lot going on here, right? Number 2, then, in the takeaways as well, I just want to reemphasize or emphasize for the first time that these are draft rules. Expect changes here. We just saw that with California. If you're subject to the California Consumer Privacy Act / California Privacy Rights Act, we just had on Monday changes to the draft rules. If you haven't tracked that, go to our blog and you can take a look at the article we put out on that. What I will say is I'm not sure that we're going to do a webinar every time we get changes to these draft rules. So do subscribe to the blog if you want to keep track of all of this, because we'll put out blog posts with talking about the changes. Okay, number 3. The draft rules do a lot here, a lot more than just operationalizing the statute. We're going to go over a lot of these topics here, but things like data retention requirements, a new sensitive data inferences category, extensive requirements around data protection assessments, loyalty program disclosures, profiling requirements, privacy notices. There's a lot to unpack here. This isn't just operationalizing the statute, it's augmenting the statute in ways that are really significant and really are going to matter for compliance. And then number 4, it dovetails into that, right? It's going to create a lot of additional compliance obligations if these are adopted without substantial change, and we'll go through that today. Time frame, TK is going to jump on that in just a second to walk you through it, but I don't anticipate it's going to be done in 2023. It's not speculation. They're not going to have the meeting until 2023, so it's not a 2022 issue. It's going to be in 2023. Okay, so I'm going to turn it over to TK, who is new to us. Maybe not new to you guys. She joined Husch about a month ago from the IEPP, where she was doing the Weston Fellowship. You may recognize her from our previous webinars. She did one with me earlier in 2022 on state privacy laws. Thrilled to have her. And TK, I'll let you jump in and talk about the current status.
Thanks for that, Dave. Yeah, so current status. As Dave mentioned, we're still months away from final regulation, but some dates to keep in mind. There's going to be the stakeholder meetings, which will be held in a few weeks in mid-November. The AG's office is scheduled to hold its public hearing on the draft rules on February 1st, after which the public will no longer be able to offer comments. 5 months later, the CPA will go into effect on July 1st, 2023, with universal opt-out mechanisms needing to be recognized by July 1, 2024, and the CPA's right to cure sunsetting at the beginning of 2025. And for comparison, here's the status of the regulations in California, which had a much shorter comment period, yet over 1,000 pages of comments were submitted. And as Dave said, those draft regulations were just recently modified, and we'll hopefully know more on this front after the board meetings later this month. And now back to Dave for a quick recap of the CPA.
Yeah, thanks, TK. And just before we move off of this slide, just to give you one piece of information. So last night, the California Privacy Protection Agency sent an email out. They canceled the board meetings for this Friday and this Saturday. So we're just going to be running with the board meetings next Friday and next Saturday. Just FYI, if you had already booked out your Saturday to listen to California Privacy Protection Agency board meetings this Saturday, you can do something better with your time. But next week you'll have to do those meetings. Okay, so what we figured is, I don't know if you guys are new to CPA or not, but I wanted to just have, I think, 3 slides quickly to just go over the contours of the CPA for anyone who's new to it. And then we're going to get on to Shelby, and she's going to dig into the rules. Okay, so scope, right? Let's just level set here. The CPA does not apply to every organization out there, right? So if this is the first time you're getting familiar with it, really need to struggle with, whether or not you actually are in fact subject to the CPA, okay? To be subject to the CPA, you have to be controlling or processing the personal data of 100,000 or more consumers. Consumers is defined to be individuals, Colorado residents, in a B2C capacity. It's not B2B and it's not employees. That is to be distinguished from California, right? So California is now going to apply to employees in the B2B as of January 1st, okay? It's not Colorado. So the 100,000 category, but not to be lost in this slide is the bottom part, which is the sell plus 25%. So if you are deriving any revenue from selling personal data, and sell isn't just sell is the transfer of personal data for monetary or other valuable consideration, and you're processing your personal information of 25,000 or more state residents, you're going to be subject to it, okay? Also worth keeping in mind, it's the only state law to date of the 5 that applies to nonprofits. But again, threshold issue about whether it applies to you or not, really keep that in mind. There's a lot of exemptions as well, so we have our GLBA entity level exemption. There's not a covered entity HIPAA exemption, but there is a PHI exemption. And there's a number of other exemptions. I really encourage you, these are examples, I should say. This is not all of them. And so I really encourage you, if you think that you may or may not be subject to the CPA, to really dig in and figure out, in fact, whether or not it applies to you. Again, there is on the bottom row, second from the left, data maintained for employment record purposes. Again, distinguish that versus California, which is going to apply to employee data January 1st. Of 2023. And we're going to dig into a bunch of these, but if you're looking for just a brief summary of what the CPA does, you get consumer rights around that. You can access, delete, port, correct your information. You're going to have to provide privacy policy disclosures. TK is going to talk about those in a second. Sensitive data, you have to get consent to process sensitive data. Shelby's going to talk about those in her slides. They've created now in the regulations a new sensitive data inference category. And you have to do data protection assessments. I'll talk about that in a little while. The last box there, data processing agreements, that's basically if you are transferring personal information from one entity to another entity, you got to have a contract in place, and that contract has to say certain things. What I will tell you is that the rules do not address data processing agreements. It's one of those areas that at least we have statutory certainty on that issue. Not to say they couldn't come back in the rulemaking process and I suppose maybe add some stuff to it, although I don't think that that's going to happen, but that's one area in which we at least have certainty right now. Okay, if you're looking for more, I mean, that was like, we do hour-long presentations on the CPA, and that was, 3 minutes. If you're looking for more, we have a lot of resources in place. You can get to our CPA Resource Center. We've got a webinar on the CPA. We've got a podcast with Attorney General Phil Weiser. We've got Q&As on this page as well. So anyway, if you're new to the CPA, we've got resources for you guys to dig in. With that, let me turn it over to Shelby, who is going to walk you guys through the consumer request process that's outlined in the draft rules.
Thanks, Dave. So diving right in here with consumer requests, those familiar with the GDPR and the CCPA are going to recognize some of the data rights that the CPA provides. To start out with, the rules do provide new requirements for the methods that controllers need to provide consumers with in order to exercise their rights. Similar to California, the rules require controllers to outline those methods in the privacy notice. The rules also require certain types of methods to be offered in different scenarios. So if you offer a website, an app, or a different digital presence, you need to offer a method through that site, app, or digital presence, such as a web form. If you only operate online, then you're required to provide an email address for certain requests. And overall, controllers just need to consider how they interact with that consumer and match the method with that interaction. So, for example, if you are interacting with a consumer in person, consider providing a printed form, maybe a tablet, or a telephone method. So how do these methods operate with requirements under other privacy laws? The rules provide that the request method does not have to be specific to Colorado if it clearly indicates which rights apply to Colorado consumers, all the rights are provided, and you provide a clear understanding of how to exercise those rights. And the method still needs to comply with the regulations. One additional note, controllers cannot require consumers to create a new account, but can require consumers to use an existing password-protected account to make some of those consumer requests. So overall, the rules require the method to be easy for consumers, and controllers shouldn't use any dark patterns when offering those methods. Similar to California, the CPA requires a response within 45 days, and if a controller denies a request, they must explain the basis for that denial and provide instructions on how a consumer can appeal that denial. The CPA and the rules do not provide exact requirements for how to authenticate a request, which is different from California. Instead, a controller needs to consider the type of right that was exercised, the type of personal data, and the level of possible harm when establishing an authentication method. So now I'm going to walk through certain requirements for specific rights. For rights to opt out, controllers must stop processing personal data within 15 days of receipt of that request, and controllers must provide an opt-out method both in the privacy notice and outside the notice. The link needs to be clearly titled. It should take consumers directly to that opt-out method. It should be in an obvious location, such as in the header or footer of a website. It needs to be available at or before the time personal data is processed. And overall, it needs to provide a clear understanding of its purpose and describe the right and instructions for how to make a request for that right. So right of access is a familiar data right. The right is somewhat similar to California. Controllers do have to provide specific pieces of information collected, including personal data obtained by processors. It needs to be given to the consumer in an understandable format. And again, similar to California, you cannot disclose information that's going to be covered by a data breach notification law, such as a social security number and a password. For the right to correction, the rules require controllers to correct data across all data flows. You have to ensure that the data remains corrected, and you have to instruct processors to also make corrections. Now, you can direct consumers to account settings to make their own correction under certain circumstances. Controllers also have the option of denying a request if they can determine that the contested information is more likely than not accurate, based on the totality of circumstances. The right to deletion, another familiar data right. The rules require controllers to permanently erase personal data or de-identify it. You have to notify processors and affiliates to also delete that data. If personal data is stored in an archived or backup system, the controller can wait until the system is restored to an active system or when it is next accessed in order to delete that information. So that's it for consumer requests, very speedy. I'm going to pass it back to Dave to talk about opt-out mechanisms.
Yeah, thanks, Shelby. So universal opt-out mechanisms, to sort of set the table for this, right? I think it's kind of a new concept for people. We've been getting a lot of questions about it from clients about what this means. And I want to level set at the beginning by saying, you know, one concept of this is the global privacy control signal. So if you are in California and you're subject to the CCPA, you're already required to recognize the global privacy control signal. That's what Sephora, in part, got in trouble for over the summer. If this is news to you, reach out to us. We can backfill in on this information. But that's one piece of the puzzle here, right? So what ends up happening is that Colorado passes its Colorado Privacy Act. As part of that, there's a piece of the opt-out rights that recognizes that controllers should recognize universal opt-out mechanisms from consumers. So what does this conceptually mean? You know, it's the difference between going onto a website like you do in California now, where you go to the bottom of the website and you have a do not sell my personal information button, and a consumer has to go to each and every single website and effectuate that request, right? That's one manner of doing it. But the concept is, well, can we create something where a consumer can make one decision to not want to be tracked across the internet and, you know, download a browser extension or use a specific type of a browser, and rather than having to go to each individual website and effectuate an opt-out request, they can just do it once. And so that's the concept behind the universal opt-out mechanism here. And then there's the opt-out preference signal in California. GPC is already required in California, but it is, you know, according to the agency, the California Privacy Protection Agency, is going to be mandatory under the California Privacy Rights Act. There's a number of people in the privacy community who think the CPRA actually makes it optional, but the agency is saying it's mandatory. What does this functionally mean? It functionally means that as of July of this year in California, July of 2023 in California, and then July of 2024 in Colorado, your website's going to have to recognize these signals. What signals is to be determined. We know GPC in California, but that's just one aspect of this. There's other signals that could be created. And that's what Colorado is trying to do with these technical specifications. And to put this in a context, California is doing this at the same time as well, right? They are issuing regulations around opt-out preference signals in California. So you need to really kind of read these together to understand what's happening, although the statutory frames of references are different between the two statutes. Okay, so maybe that's too long of an explanation. Oh, and you know, Connecticut's going to jump in as well, right? So Connecticut's not going to issue regulations, but they are going to require the opt-out preference signals be recognized. In their bill, they matched it to the Colorado statutory requirements. So the idea is whatever Colorado comes up with is going to work in Connecticut, you know, in theory. Okay, so to walk through this, you know, these draft rules in the top part here, they issue the technical specifications, right? At least set the contours for that. But they also recognize that it could be a signal, or it might also be maintaining a do not sell list, so long as controllers are able to query that list in an automated manner. Really, I think some issues to be fleshed out here about how exactly that would work. The good news is, right, the AG's office in Colorado is going to publish a list of recognized universal opt-out mechanisms, UOMs, I guess is what we're going to call this as the acronym. They're going to publish a list. by April 1st, 2024. So that's at least going to make compliance a heck of a lot easier to drive here by April 1st, 2024. We'll have a list in Colorado, at least. The notice aspect of it, the controller is permitted, but it's not required, it's not mandatory to display that it's recognized the opt-out preference signal when you show up on a website. This is significant because this, in California, at least in the initial draft rules of California CPRA ones, this was going to be mandatory, but on Monday they backed that down. On Monday they made that permissive as well in California, right? And so, again, these things are susceptible to change. They are going to change over time, and we just have to kind of make sure that we track all of these things. Pop-up banners, I did see a comment a question in the Q&A here asking about pop-up banners. There is language in the existing Colorado draft rules that talks about you can't use a pop-up banner to seek consent to overrule a universal opt-out mechanism because that's going to degrade or obstruct the consumer's experience. Frankly, I was hoping, and we asked for in our comments to the AG's office during the rulemaking process, we asked them to provide more clarity around cookie consent banners and how they would work. They haven't to date. Maybe we'll get it down the line as these things get fleshed out. But, to the point of the second bullet point there, you could, place, there's a discussion in the rules about placing like at the top of the header to say, to obtain consent to go around the universal opt-out mechanism. So a difference between like a cookie banner and like something on your website in a sense. There's other aspects of these regulations. It goes on for 4 pages in the draft rules. You're going to have to make sure the technical specification, that is, like the actual technical specification, is going to have to make sure that you can recognize somebody as being from Colorado. So it has to actually recognize as a Colorado resident. That's one thing that's going to have to get across the finish line there. And then it can't be by default either. So like, you can't have an operating system that makes this privacy setting by default. The user actually has to consent to it. They have to opt into it. So like, for example, you would go on and, download OptOut as a browser extension, or Blur or Privacy Badger as a browser extension, or use DuckDuckGo or use Brave. What I'll say is, and I see there's a lot of questions on this issue in the Q&A. There was one I did want to hit on, which is, to confirm GPC is required to be recognized in July 2023. So, no, to be clear about that, today in California, yes, you need to recognize GPC in California today. That's what Sephora got dinged for. Presumably, Colorado will recognize GPC as one of these valid opt-out mechanisms when it publishes its list in April 1st, 2024, but Colorado has not come out and said GPC must be recognized. But it is a today thing in California, so, yes, get yourself aligned if you're subject to the California Consumer Privacy Act. Okay, there's a lot of questions, and hopefully I'll be able to address those in emails afterwards, but we do want to move on and hit some other topics. And I will turn it over again to TK.
Thanks. Yeah, so privacy notices. Some high-level notice requirements that may sound a little familiar to you. All notices must be understandable to the controller's target audiences. They must use plain, straightforward language and avoid technical or legal jargon. They must be reasonably accessible to consumers with disabilities. So for online notices, controllers must adhere to generally recognized industry standards such as the Web Content Accessibility Guidelines. They must also be available in the languages that the controller conducts business, and they need to be readable on all devices through which the consumers interact with the controller, including on smaller screens and through mobile apps, if applicable. As for the listed privacy notice principles, it's not Colorado specific. As long as it contains all required information, controllers need not provide a separate Colorado-specific privacy notice or Colorado-specific section in their privacy notice. The notices must be clear. The information provided must be concrete and definitive, avoiding terms that could lead to varying interpretations, and they must be clearly labeled so consumers can easily navigate the privacy notice. They must be accessible. Controllers operating a website must post their notice online through a conspicuous link using the word privacy on their homepage. Those with a mobile app must provide this link in the App Store page or the download page, as well as in the application settings menu. And privacy notices must be specific. The level of specificity provided should enable consumers to understand the scope of the controller's processing, such that consumers should not be taken by surprise later on about the data that's been collected and the ways it's been processed. So in contrast with the CCPA's notice requirements, which tend to focus on categories of personal information, the Colorado draft rules center these requirements around processing purposes, which, if kept as currently drafted, may create some interoperability challenges when put into practice. But under the draft rules, privacy notices must include a comprehensive description of online and offline data processing practices, including for each processing purpose, a meaningful description of the processing purpose, the categories of data processed, sold, and or shared, the categories of third parties to whom the controller sells or shares data, and for each processing purpose, whether the data collected is sold or processed for targeted advertising or profiling. In addition to those purpose-centric processing disclosures, notices must also include a list of the available data rights, a description of the methods of how consumers may submit requests, which will require additional inclusions as well. If applicable, information regarding sensitive data inferences, which Shelby will touch on in a minute. Contact information, how consumers may appeal a controller's action regarding their requests, and like the CCPA, they must include a last updated date. The draft rules also require controllers to notify consumers of any substantive or material changes 15 days, calendar days, before the change goes into effect. This includes changes to the categories of data processed, processing purposes, a controller's identity, or the methods for consumers to submit requests. And as currently drafted, it seems as though notice must be made exactly 15 calendar days before any changes go into effect, but we're thinking that'll be addressed before the rules are finalized to allow for notices to be made up to the 15-day deadline, not just exactly 15 days. So some other data processing requirements. Purpose specification, meaning controllers must specify the express purpose for the collection and processing of personal data in both external disclosures to consumers and in internal documentation. The express purpose needs to be described in a sufficiently unambiguous manner such that the processing is understood by and predictable to the average consumer, third parties, enforcement authorities, etc. If data is processed for multiple purposes, the controller must specify each unrelated purpose. Furthermore, controllers must obtain consent before processing data for purposes not reasonably necessary to or compatible with specified processing purposes, which is a mouthful. If a new processing purpose is unexpected, unnecessary, unconnected, or would have an unjustified negative impact on the consumer, it'll not likely be considered reasonably necessary or compatible with the original purpose. And the draft rules list 7 factors for controllers to consider when making this determination, such as reasonable consumer expectations and possible consequences or impact to the consumer. So controllers must also determine the minimum data that's necessary, adequate, or relevant for each express purpose. And they also have to document such according to the rules, which are currently fairly prescriptive. The draft rules also state that data should be only kept for as long as necessary for the express purpose. And to ensure that it's not being kept beyond that, the rules hint at imposing a data retention schedule requirement by requiring controllers to set specific time limits for erasure or to conduct periodic reviews. And any data determined to be no longer necessary, adequate, or relevant to the express processing purpose, it must be deleted by the controller and its processors. Further, controllers must annually review the retention of biometric identifiers and obtain consent to process this data each year after the first year it's stored. So yeah, a lot to deal with. And now I'll turn it over to Shelby to discuss loyalty programs.
Thanks, TK. So I'm going to cover some of the new requirements for loyalty programs. The rules provide that controllers cannot increase the cost of or decrease the availability of a product or service solely because a consumer exercises a data right. However, controllers can offer bona fide loyalty program benefits based on whether a consumer wants to participate in a loyalty program. So what is a bona fide loyalty program and benefits? The rules did add new definitions for both. A bona fide loyalty program is going to be a loyalty, reward, premium feature, discount, or club card program that is established for the purpose of providing discounts, rewards, and other value to consumers that want to voluntarily participate in that program. And then the benefit is the actual offer that is provided to the consumer through that loyalty program. The rules provide a number of new disclosures that controllers need to provide in their privacy notices, loyalty program terms, and any consent disclosures, including the list that I have provided here on the slide, categories of personal data that's collected through the program and has been sold or processed for targeted advertising, the categories of third parties that are receiving the personal data. An interesting one is the value of the benefits available to a consumer if that consumer opts out of sale or the processing for targeted advertising versus if they decide not to opt out of the sale or processing for targeted advertising. And then a list of benefits that do require processing of personal data for sale or targeted advertising and the third party that's receiving that personal data. So now I'm going to switch over to sensitive data. And just really briefly, the statute already defines sensitive data as personal data revealing racial or ethnic origin, religious beliefs, mental or physical health condition or diagnosis, sex life, sex orientation, citizenship, genetic or biometric data, and personal data from a known child. Controllers do need consent to process sensitive data, and Dave's going to talk about consent in a little bit. And what's interesting is this new sensitive data inferences category. The draft rules do require consent to process inferences, and this consent needs to be refreshed annually for the processing of sensitive data. So very interesting that they're expanding this consent requirement to inferences. So where did they get sensitive data inferences? In the definition of sensitive data, it includes that word revealing. And so then the rules added a new definition of revealing that includes sensitive data inferences. And then they added another definition of sensitive data inferences, which is any inference that is made by a controller based on personal data alone or in combination with other personal data, which can indicate sensitive data. So what does that actually look like? The rules do provide a few examples. Geolocation data may be showing an individual visit a mosque is sensitive data if used to indicate religious beliefs, or web browsing data can be considered sensitive data if it's used to create a profile that indicates a consumer's sexual orientation. So luckily the rules do provide a few examples of what inferences will look like. As I mentioned, inferences do require consent prior to processing. However, the rules do allow controllers to process sensitive data inferences without consent if the following on the slide apply, and if the individual is over 13. So the processing purpose must be obvious. The inferences have to be deleted within 12 hours, which is a quick turnaround. You have to include information about the inferences in a privacy notice, and inferences cannot be transferred, cannot be sold, shared, or processed for any purpose other than that disclosed express purpose. So big changes there that are going to need to be considered. One last note for sensitive data is the rules did add definitions of biometric data and biometric identifiers, which we didn't originally have. It's important to note that the biometric data definition includes any biometric identifiers that are used for identification purposes. So now, as I mentioned, I'm going to pass it back to Dave to discuss how you can get this consent and those requirements.
Yeah, thanks, Shelby. And before I get to consent, there was a question that came in that I think probably is on the minds of a lot of people, so I wanted to just at least tease it out. And the question is, how do we square the Attorney General's preference for interoperability with the focus on processing purposes, unlike the CPRA? Do we think that's an area likely to change? So this goes back to TK's discussion of how the privacy notice is supposed to be laid out, and it's this idea in the Colorado draft regulations that the privacy notice is supposed to be wrapped around processing purposes. And so, California is very much wrapped around the idea of personal information. So you identify the personal information you collect, and then you identify sources, and third parties, and the business purposes, those types of things. And Colorado is as it's currently written, and we'll see where it goes, is wrapped around this idea of doing around business purposes. And there is, I mean, to the point of the question here, there is a tension, and what I will say is as part of the rule package, at the end of the rule package, there's a number of pages that the Attorney General's office dedicates to asking questions about their approaches to various things. And this is one of the questions that they specifically raise, where they say, is having privacy notices wrapped around processing purposes, is that going to create too many interoperability issues? And so, a lot of these concepts that we talk about today are, like we keep on saying, subject to change and subject to comment as well. And I think, it's important for people if you see this and you think, my goodness, this is going to make life more difficult than it needs to be for purposes of drafting privacy notices, there's an opportunity to comment and an opportunity to make that point. I think there's a valid argument to be made that having more and different types of approaches to privacy notices has the opposite impact to what the privacy community should want. It hurts transparency when you have a Colorado notice and a California notice and a GDPR notice and those types of things. So it's a great question. I think it is very much a to be determined. I can't say whether it's likely to change or not. All I can say is based on what we've seen in the comments themselves is something I think that they're wrestling with. And I think just in general, too, what we've seen out of the Colorado Attorney General's office to date is really a willingness, a desire to engage with stakeholders and to hear their opinion and try to get this right, which I think is really important. That they've had a number of meetings with stakeholders, they've asked for comments in the preliminary process. They want more comments. There's stakeholder meetings in November. So yeah, I mean, feel free to engage in this as much as you can. Okay, off my soapbox here, but I thought that was a great question to ask, and something somebody was thinking about. A lot of people will be thinking about. Let's talk about consent. Excuse me. So we had a number of questions come in to talk about consent in the Q&A. The Colorado Privacy Act requires consent in 4 different instances, and they actually spell it out in Rule 7.02 of the draft rules. And it's for sensitive data, so Shelby just talked to you guys about sensitive data. Processing for a known child, so that's going to be under 13, right? So lining that up with COPPA. And then, you know, if somebody's exercised their opt-out rights, so that'd be like the opt-out of sale or certain types of profiling or targeted advertising, you can have consent to subvert that. And then the last one is this concept that TK was talking about, which is this reasonably necessary to or compatible with concept. I actually think there's one missing in the rules here, because you can also, that universal opt-out mechanism, you can get consent around that, but I think that's kind of bootstrapped in with the opt-out number 3 there they talk about. So it's different than California, right? So California has consent as well, but there's not this upfront requirement for consent for the collection of sensitive data. And somebody asked the question too, I mean, you know, we talked about this, that there is a lot in consent that needs to be unpacked with these rules. This concept of having annual refreshing of consent for certain things like biometric identifiers and sensitive data is something that really needs to be thought a lot about. And, you know, like I said, there's some subtleties here that could really have some big impacts on how we go about doing it. I'm going to talk about it in a second about like what happens July 1st with consent, right, prior consent. So I'll get to that in a second here. But to have the valid consent, and what are the boxes that we need here, right? We need 5 requirements for valid consent. They identify these in the draft rules, and this is the definition of consent in the statute itself, right? What I'll say here is, you know, when you look at these 5 different boxes here about what are the building blocks of valid consent, when you look at the draft rules that they've issued, and it's part 7 of the draft rules, it is really reminiscent about the European Data Protection Board guidance on consent, where they go through each of these individual requirements, say, you know, affirmative action freely given, and they specify, you know, what it is to actually do those types of things, and they give examples and things of the like. And so I think the Attorney General's office has done a really good job of spelling out what they want for consent, because it is a big deal under the Colorado Privacy Act, given that, you know, this model has consent as a basis for those things I talked about, whereas California is a different type of model. Now, one thing I do, and I teased this a second ago, but I really do want to make sure that we sort of emphasize it here, is if you look at section 7.02, I doubt you all have the draft rules in front of you, so I will just kind of tease it out for you. If you look at 7.02b, it talks about controllers may rely upon valid consent obtained prior to July 1st, 2023 to continue the process a consumer's previously collected personal data, including sensitive data collected before July 1st, 2023. So that sounds great, right? We can, the CPA goes into effect on July 1st, 2023, and we can rely upon valid consent obtained prior to July 1st, 2023. But then the next sentence, first sentence giveth, and the next sentence take it away, and it says consent obtained before July 1st, 2023 shall be considered valid only if it would comply with the requirements set forth in, and then they rattle off a number of portions of these statutes here and the regulations. And then it says if a controller has collected sensitive data prior to July 1st, 2023 and has not also previously obtained valid consent to process such sensitive data, the controller shall obtain consent as required by July 1st, 2023 to continue to process the sensitive data. So there's a lot to unpack there, and we'll see where it goes with the draft rules. But, you know, this idea of, as of July 1st, 2023, what do we do with our data storage that we have around sensitive data and things of the like is going to be something that, if these draft rules hold out the way that they're approached, is going to have to be analyzed, as well as the same concept that Shelby was talking about before, which is this, you know, refreshing of consent around biometric identifiers and sensitive data and the data minimization principles there, which TK was talking about too, which is functionally like requiring you to have things like data retention schedules and actually to abide by those data retention schedules. So it all kind of pieces together, kind of fits together, and important to kind of see how that it does this in draft regs. Okay. So the principles then, and somebody asked about this before. I didn't answer the question because I wanted to get to this slide. So the idea is like, what is consent, right? And the specific question that came in the QA was, is silence consent? No, silence is not consent. And that is specifically spelled out in these rules. You can't use a blanket, acceptance of general terms and conditions. You can't bundle consent with other terms and conditions. It can't be an activity, right? It has to be an affirmative action there. There's actually in the statute itself, the definition of consent talks about hovering over is not enough, right? No pre-ticked boxes, right? Which is, I know, a big deal that we talk about with clients all the time. And it has to be, consent has to be to each unrelated incompatible processing purpose, right? So I think what we're really talking about, again, this is this GDPR concept of consent from the EDPB guidelines, right, is consenting to each individual processing activity or potential processing activity if they're incompatible or different. Really kind of saying like, if you look at the EDPB guidance, right, about consenting to marketing activities versus consenting to receive, certain types of information from a business and whether those are separate and, whether you need to have individual boxes and obviously unpre-checked boxes. These are the things that we are really going to be thinking about and really need to be thinking about before July 1st, 2023 in light of what I just told you before, which is, will consent that's obtained before, have you obtained consent properly, right? Or have we not even thought about that in this country because we don't have these rules yet? So a lot of things are really coming to be teased out and thought through. Informed is another aspect as well. So if you look at the draft rules around this concept, and you really kind of get the sense on page 23 of this that informed consent is going to be a big piece of the puzzle here. And so you need to identify all of these things, right? You have to identify the controller, that's the main business collecting it, why the consent is required, the categories of personal data that are going to be collected, and then on the bottom right there, the description of the right to withdraw consent. So you will not find in the Colorado Privacy Act itself the concept of withdrawing consent, but they clarified in the CPA regulations, rules I should say, that an individual has the right to withdraw consent. Right. This was in Connecticut. It was added to the Connecticut bill. Now it's found itself into the Colorado regulations. This is a really good example of states building off of one another as they push forward with these privacy laws. What I will say too is, when they talk about consent, they talk about linking these, right? So the concept is like, well, how does it look like on my web page, right? What does it actually look like to obtain consent? And what they told you is in the draft rules, that is, that you can provide these disclosures in your privacy policy and then provide a link when you're obtaining consent to the privacy policy, right? But now this concept I talked about when I started, of privacy policies, and whether you can, have one privacy policy as to, multiple individual pieces of them becomes even more complicated because now I'm driving after a concept around consent for processing activity that exists only in Colorado, Connecticut, Virginia, doesn't exist in California necessarily, right? And then Shelby talked with you guys about loyalty programs and the material terms of loyalty programs. You can have those in your privacy policy as well. Point being is there's a lot to unpack, a lot of moving pieces here. And once these rules firm up, we really need to kind of dig in and get our hands dirty and figure out how we're going to lay all of this stuff out on your website. It's becoming, privacy law is becoming website design, right? And apropos of that, that's a perfect segue to go on to the next topic, which Shelby's going to join in on, which is UI design, choice architecture, and dark patterns.
Yeah, thanks, Dave. So the statute references dark patterns, and the rules kind of take this a bit further with user interface design and choice architecture when it comes to gathering that consent. Overall, controllers cannot use an interface design or choice architecture that has a substantial effect of subverting or impairing a user's autonomy, decision-making, choice. It can't unfairly, fraudulently, or deceptively manipulate or coerce a consumer into providing consent. And the rules actually lay out 9 different principles that need to be considered with this user interface design. and choice architecture. So I'll briefly just cover these 9 different principles. You need to offer symmetrical consent options, an accept and a do not accept button, both in the same font, size, and style. One of my favorites is the guilt, shame, and emotionally manipulative. You can't do that. I think we've all seen examples of this. I want to help endangered species versus no, I don't care about animals. So you can't offer those 2 choices. And then like Dave said, you can't, silence or failure to take action is not going to be consent. Do not present consent options in a pre-selected or default option. So like Dave said, that pre-selected checkbox that we sometimes see. Both consent choice options need to have the same number of steps. So if you don't accept, it shouldn't take you to an additional page. And then you shouldn't interrupt a user's experience just to request consent. And then the last 3, don't use misleading statements, intentionally confusing language. Definitely consider vulnerabilities for those websites that are directed to individuals under 18. Consider simplifying that language. Like Dave was touching on, this may get a little more difficult with everything we need to include in websites, but consider that. And then everything needs to work the same way through digital accessibility tools as well. So I'm going to hand it back to Dave for data protection assessment.
Yeah, thanks, Shelby. So 2 topics left to go, data protection assessments and profiling. I got to say that I'm a little bit disappointed. I'm looking at the Q&As, and we have yet to get to somebody who's asked us what the status of the ADPPA is. Usually that's like the first question, right? Are we going to get federal law after we start digging into all these things? And nobody's asked it yet, so we'll see. Now I'll probably get like 3 or 4 people asked. So anyway, so data protection assessments. Okay, this is, you're going to see this in Colorado, Connecticut, and Virginia, right? So these data protection assessments, but Colorado is the only one who's issuing rules on data protection assessment. Virginia's got no regulations, Connecticut's got no regulations, Colorado does. So when do you have to conduct data protection assessments? Colorado law tells you, statutorily tells you when there's a heightened risk of processing activity harming consumers, right? And they give examples: targeted advertising, sale personal data, processing sensitive data, and then certain types of profiling. And TK is going to talk about the profiling, which is really interesting, a lot of fun to unpack the profiling stuff. So Connecticut's law marries up against this structure here, and then Virginia's close enough, right, on this structure. So if I look at the statute here, the statutory requirements, if you look at the statute itself, the statute, I counted this before I jumped on this morning. I counted the number of words in the statute of what needs to be in a data protection assessment. There's 96 words of what describes what needs to be in a data protection assessment. It is all of a paragraph of the statute itself, right? The regulations have 4 pages dedicated to what needs to be as part of a data protection assessment, okay? So it has to be, and there's general constructs here, a genuine and thoughtful analysis. At a minimum, that data protection assessment has to describe 18 different topics. So I'm going to have 3 slides in a second that just show you the topics. I'm not going to go through them because you'll kill me, but I'll just show you the topics. It has to involve internal actors and external actors, and you've got to do it. Importantly, you've got to do this data processing assessment before initiating the process activity. So it doesn't, the duty doesn't start until July 1st, right? But again, you got to be thinking about these things like we talked about before. It's like consent and retroactive and how I do all these types of things. Your data protection assessments. Point being is there's a lot of work to be done, right, between now and then to make sure that things are buttoned up. And that box there too next to it must update DPA periodically. So if you're doing profiling DPAs, which TK is going to talk about in a second, you got to do that annually. If you modify your processing activity, you're going to have to refresh it. And other than that, you're going to have to do it on a I think the phraseology is on a as needed type of a basis, right? So you can't just like, hey, you can be done with it, put it in the drawer, and forget all about it. Depending on the type of processing activity, you may be having to revisit it. And you're supposed to store it for 3 years after the processing activity ceases. The Attorney General, in the final box there, can request your DPAs on 30 days notice. The statute says the Attorney General can request them. but doesn't give the time frame. So here it's 30 days to request them. I should note in the 4 pages of rules around this, there's a discussion about DPA should be proportionate to the size of the controller, the amount and sensitivity of personal data the controller has, as well as the processing activities, right? And so, depending upon the size of the company, I think you're basically recognizing, mom and pop store versus, multi-billion-dollar company. There's going to be differences in the DPAs here. But when you look at the topics that you need to go through, there's a lot of topics that you need to go through. And for people familiar with GDPR, I think you're going to see a lot of the same topics that you see with GDPR. But for those unfamiliar with GDPR, it's going to look like a lot. And probably, again, I'm not going to read all these topics, but as you go through this, one other thing to kind of tease out is that some of these numbers have subparts to it as well, right? So a lot to dig into here. The one I kind of thought was interesting worth talking about a little bit was number 11, which is the sources and nature of risks to individual consumers. It actually lists in the rules 11 different types of harms. So you have to be considering constitutional harms, intellectual property harms, data security harms, discrimination harms, privacy harms, psychological harms. There's others that I'm not listing here. So some really thoughtful, again, they want a genuine, thoughtful analysis of how you're tackling these types of issues. And just give you the last few here. Again, this will be in the deck that you can download, and obviously it's in the rules itself. And what I'm really trying to leave you here with is not hey, there's a lot of words on paper. What I'm trying to lead you here with is the AG's office has really dug in here and fleshed this issue out, and it's going to be something that we're going to have to tackle with. Okay, last topic is profiling, and I'm going to turn it back over to TK.
Yeah, thanks, Dave. So last, but certainly not least, profiling. So the text of the CPA provides consumers the right to opt out of profiling when done in furtherance of decisions that produce legal or similarly significant effects concerning the consumer. And the CPA itself defines these terms as we have on the screen here, and it includes a handful of requirements for profiling activities, but the draft rules, they kind of clarify these requirements and their implications. So, for example, the draft rules outline what controllers need to disclose in their privacy notice, including, at a minimum, what decision is subject to profiling, the categories of data that were or will be processed for profiling, a plain language explanation of the logic used in the profiling process, why profiling is relevant to the ultimate decision, if it's used to serve ads for housing, employment, or financial or lending services, as well as some additional disclosures. But the draft rules do make it clear that none of the requirements shall be construed as requiring controllers to disclose trade secrets. So there is that. The draft rules also distinguish between the automated processing used in profiling based on the different levels of human involvement, noting that increased human involvement may offer corresponding levels of consumer protection. So controllers must honor opt-out requests if the profiling is based on solely automated or human-reviewed automated processing. But if the profiling is used, if it uses human-involved automated processing, then controllers may decide not to take action, provided they inform the consumer and include a 7-part explanation, including things like a non-technical explanation of the role of meaningful human involvement in profiling and the decision-making process, and how consumers can correct or delete the data used in the profiling. And as Dave mentioned, the draft rules, they reiterate the CPA's data protection assessment requirement for certain types of profiling, but they also create additional requirements. For instance, data protection assessments involving profiling must include 12 additional profiling-specific topics on top of the 18 topics already required for these assessments that Dave ran through a minute ago. So that's a lot to cover in a data protection assessment for profiling. Controllers will also be required to annually review and update these assessments, which have to include an updated evaluation for fairness and disparate impact, as well as the results of the evaluation. And we are right on time. With that being said, I'll hand it back to Dave.
Yeah, thanks, TK. So, we've had a conversation with you guys before about, subscribing to the blog and just this, I always call this the shameless plug portion of the webinar, right? But what I will say is, obviously there's new drafts, right? And so, if you want to keep tracking this, encourage you to just use the QR code there. We push out articles every time something like this happens. Just did one in the CPRA change in regs, earlier this week. So again, hope that you'll subscribe to the blog and keep on tracking us, friend and like us or friend or follow us on LinkedIn. Okay, with that we are done. I know we didn't get to every question that came in, but we'll try to revert on those questions that did come in. There will be a recording of this available that you can, you'll get tomorrow. You'll get an email and it should have the recording in it in case you want to share it, or for some reason have insomnia and need to fall asleep at night. It's a good opportunity to do that. So anyway, with that, I just want to thank you for attending and hope to talk to you all soon. Thanks.